Hello, this is David Kupetz. I am a member of the law firm SulmeyerKupetz. Our focus is financial restructuring, business reorganization, bankruptcy, and other insolvency situations and solutions such as assignments for the benefit of creditors. Today's webinar will discuss issues connected with the enforceability of restrictions on filing bankruptcy, pre-bankruptcy waivers, and corporate governance in the context of Chapter 11. State law determines who has the authority to file a voluntary bankruptcy petition. The Ninth Circuit recently, in a case called Sino Clean Energy at 901 F. 3rd 1139, it's a 2018 decision, reached the unsurprising conclusion that former board members lacked the power to authorize the filing of a bankruptcy petition by the corporation. In that case, there was a situation where, as part of litigation brought by a group of shareholders, the state court had appointed a receiver for the corporation and granted the receiver the power to reconstitute the board, which is what the receiver did. And after the new board was appointed, former directors purported to authorize a Chapter 11 filing for the corporation. The Ninth Circuit in the case upheld the bankruptcy court's dismissal of the Chapter 11 case since the petition had been filed without corporate authority and relied on longtime Supreme Court precedent in a case called Price v. Gurney, a 1945 decision that held that state law determines who has the authority to file a bankruptcy petition. In Sino Clean Energy, the Ninth Circuit distinguished a case where a state court enjoined a corporation from filing bankruptcy altogether, finding that in that situation, federal bankruptcy law would preempt that injunction. But in contrast, in the Sino Clean Energy case, the corporation was fully able to file for bankruptcy if it had been authorized by its eligible board of directors, which had not happened. Pre-bankruptcy waivers of the right to file bankruptcy are generally unenforceable, while prohibitions in entity governance documents, including restrictions or requirements with regard to filing bankruptcy, are generally enforceable. However, it becomes less clear where a creditor or a party wearing both creditor and equity holder hats is able to obtain a waiver or restriction on bankruptcy filing by having it included in the entity governance documents. The Fifth Circuit's 2018 decision in Franchise Services of North America addressed a situation where the holder of 100% of the debtor's preferred stock was also a creditor of the debtor. Moreover, the corporation's certificate of incorporation required the consent of the preferred shareholder to any voluntary bankruptcy filing by the corporation. Now, much of the law in this area has arisen in the context of so-called special purpose entities. It is generally understood that an entity otherwise eligible to be a debtor in bankruptcy can really never be fully bankruptcy proof. However, lenders seeking to minimize bankruptcy risk and borrowers seeking to access lower cost capital often agree to establish a new SPE, a special purpose entity, designed to be a bankruptcy remote borrower entity. The typical SPE structure includes both restrictions in its governing documents and credit agreements that try to preserve the separateness of the SPE so it won't be consolidated or treated along with other entities and so the debt doesn't spill over, and also often try to restrict its access to file for bankruptcy. SPE governance documents often include covenants prohibiting a bankruptcy filing, requiring an independent director that is approved by the lender, or requiring a unanimous vote to authorize a bankruptcy filing. While blatant prepetition waivers and third-party agreements, such as the secured creditors financing documents, are consistently seen as void against public policy, courts have taken a seemingly less than consistent approach when it comes to considering restrictions in the debtor's governance documents that themselves are often tantamount to a bankruptcy waiver. In franchise services, the Fifth Circuit explained that case involved a bona fide shareholder. The equity investment made by that shareholder was $15 million, and the debt that was held was just $3 million. The Fifth Circuit stated that it was not confronted with a case where the creditor has somehow contracted for the right to prevent a bankruptcy, or where the equity interest was just a ruse. Recognizing that state law dictates the procedures an entity must follow to authorize a bankruptcy filing, the Fifth Circuit found that, and the Fifth Circuit's decision is at 891 F. 3rd 198. Again, it's a 2018 decision. The Fifth Circuit found that federal law does not prevent a bona fide shareholder from exercising its right to vote against a bankruptcy petition just because it's also a creditor. Further, the court explained that when authority to enter bankruptcy is lacking under state law, the bankruptcy court has no alternative but to dismiss the bankruptcy case. The Fifth Circuit acknowledged that pre-petition waivers of the right to file bankruptcy have been found to be unenforceable and cited other circuit court decisions, including the Ninth Circuit's decision in Thorpe Insulation Co., which is at 671 F. 3rd 1011. In that case, the court stated that the prohibition of pre-petition waivers has to be the law because otherwise creditors would routinely require debtors to waive their right. In franchise services, the Fifth Circuit pointed out that it was not addressing a waiver case. And what it stated that as the case was framed, the Fifth Circuit could assume without deciding that such a waiver would be invalid, and the court said it would leave the resolution of that issue for another case, one in which the issue was squarely presented. Accordingly, the Fifth Circuit really did not address head-on whether a golden share, and that's the term that's sometimes used in the bankruptcy context when you have a share or shareholder rights that provide the power to block a bankruptcy filing. The Fifth Circuit didn't address whether, directly at least, whether that would be valid and enforceable. Rather, in summary, the Fifth Circuit stated that no statute or binding case law licenses this court to ignore corporate foundational documents, deprive a bona fide shareholder of its voting rights, and reallocate corporate authority to file bankruptcy just because the shareholder happens to be a creditor. The court limited its holding with regard to federal law to the conclusion that federal bankruptcy law does not prevent a bona fide equity holder from exercising its voting rights to prevent the corporation from filing a voluntary bankruptcy petition, because it also holds a debt owed by the corporation and owes no fiduciary duty to the corporation or its fellow shareholders. So that's the twist on it, that in order to have that position, the shareholder might be in violation if it owed a fiduciary duty and then was going to violate that duty by blocking the filing. The Fifth Circuit said a different result might be warranted if a creditor with no stake in the company held the blocking right, or if there was evidence that it took an equity stake simply as a ruse to guarantee that it was going to get paid on its debt. And the Fifth Circuit stated that it was leaving those questions for another day. In the bankruptcy context now, waiver issues have most frequently arisen in the context of the automatic stay. And while it's true that courts have generally treated waivers of the automatic stay as unenforceable when they are contained in pre-petition agreements between a lender and a borrower, based on the rationale, in large part, that the interests of third parties, such as unsecured creditors, for whose benefit the automatic stay in a subsequent bankruptcy case would exist, were not considered at the time that the agreement was made. The same can't be said for waivers that are approved after notice and an opportunity for hearing in the context of an earlier bankruptcy case. At least some courts have taken that view. It's not a universal a view, but it's a view that's been taken by certain courts. So generally speaking, the automatic stay can't be waived, or it's not generally going to be enforceable. Now, that there is some balancing there, and there are some inconsistent views. However, when such a waiver is made as part of a confirmed plan or a court-approved settlement, either with the consent of unsecured creditors or after they have received notice and had an opportunity to object, absent changed circumstances, such waivers have been routinely enforced. Cases that stand for that proposition include BGM Pasadena, which was a 2016 decision in the Central District of California, and Hirsch Realty, a 2018 decision out of a Massachusetts bankruptcy court at 583 BR 583. Courts have taken a variety of approaches to pre-petition automatic stay waivers that aren't implemented through a prior bankruptcy case. They've emphasized either that they want to encourage out-of-court settlements, and these frequently take place as part of workouts or forbearance arrangements, for example, and they weigh that against countervailing concerns of promoting reorganization and equality of treatment among creditors. Atrium High Point at 189 BR 599 is a case that includes an early collection of early cases addressing pre-petition automatic stay waivers. In my view, the better or majority view is that these pre-petition waivers and loan agreements are unenforceable as a matter of public policy, and upholding pre-petition waivers of this sort deprives the debtor of the breathing spell contemplated by the Bankruptcy Code and thwarts congressional intent underlying the imposition of the automatic stay. It's certainly not a universal view, but I think that generally is sort of the majority view. And to see a case addressing that, take a look at Benfield, B-E-N-F-I-E-L-D Nursery, a 2017 decision at 565 BR 603. In any event, even when enforced, stay waivers are found not to be automatic or self-executing. So a pre-petition automatic stay waiver needs to be addressed in the bankruptcy case. The beneficiary of that waiver shouldn't just treat it as if it's self-executing and automatically enforceable. The court in Hirsch Realty, again, that's a case at 2018 bankruptcy court decision at 583 BR 583, recognized that courts are divided as to the enforceability of pre-petition waivers of and restrictions with regard to bankruptcy relief, even if they appear in court-approved documents, so even if they came out of a prior bankruptcy case. And in that case, the court agreed with those decisions in which courts have upheld contractual provisions waiving protections afforded by the automatic stay when they are included in prior bankruptcy court orders. So in a prior case, approving settlement agreements or confirming a prior Chapter 11 plan. However, the court did employ a multi-factored approach. So it was saying, hey, those waivers can be enforceable, but a number of factors have to be considered. And those factors are listed on that court identified on this slide, and it includes things such as the sophistication of the parties, what was involved in terms of consideration, whether other parties are affected, the feasibility of the plan if there was a plan involved, public policy concerns, and various other factors that you'll see listed on this particular slide. Fundamentally underpinning the Fifth Circuit's decision in franchise services was the concept that just because a shareholder happens to be an unsecured creditor, there isn't any binding case law on that basis alone, or any statutory provision that says that any right of that shareholder is necessarily stripped away. Now, clearly the court recognized that if the creditor had basically acquired its equity interest in order to protect its rights connected with its debt, that the result could very easily be the opposite, that could be found either to be a ruse, or that really the debt rights and the debt concerns of that particular party were taking precedence over and trumping their rights as a shareholder. Parties to an operating agreement generally have freedom to contract, which is limited only by the parameters in the relevant governance documents. So at the same time, there's a strong federal policy in favor of allowing the right to a fresh start or the opportunity to reorganize in bankruptcy. Contractual provisions in operating agreements that prohibit a company's ability to file bankruptcy without a creditor's consent are void. Now, that is not to say that members of a business entity cannot freely agree among themselves not to file bankruptcy. However, an independent decision maker, a member of the board, for example, or this would also apply in the context of LLCs, has to be careful and shouldn't simply exist to vote no to a bankruptcy filing. That's what happens in some of these SPEs where the lender puts a board member in place. Now, that board member needs to be aware of his or her fiduciary obligations, which continue to apply regardless of how they were placed on that board. After addressing federal law, the Fifth Circuit in the Franchise Services case turned to whether Delaware law allowed the shareholder to exercise a blocking right. And the Fifth Circuit pointed out that Delaware corporate law is generally regarded as the most flexible in the country. It explained that under Delaware law, a shareholder is generally free to act in its self-interest, unencumbered by any fiduciary obligation. However, there's two significant exceptions that the Fifth Circuit recognized. One, if the shareholder is a majority shareholder, and second, if the shareholder is found to be a minority controlling shareholder. Now, the shareholder in Franchise Services was not a majority shareholder, so the Fifth Circuit found no need to examine or speculate what would follow if it had been. The Fifth Circuit found that the standard for minority control is a steep one. Potential control is not enough. In the Franchise Services case, the shareholder's right to appoint 2 of the 5 directors was insufficient to demonstrate actual control. That's what the court found. And there was no evidence that the shareholder dominated the entity's corporate conduct. Further, the court found that the corporation's willingness to act by authorizing the Chapter 11 filing, which had happened in that case, without the preferred shareholder's consent, undercut the case that the debtor subsequently was trying to make, that the shareholder had a controlling position and had violated its fiduciary obligations as a result by not being on board for the bankruptcy filing. Concluding that the shareholder did not qualify as a controlling shareholder under Delaware law, the Fifth Circuit said, we need not and we do not decide whether it breached a fiduciary duty. Finally, the Fifth Circuit held that even if it had found that the shareholder had breached a fiduciary duty as a controlling shareholder, the proper remedy would not be to deny an otherwise meritorious motion to dismiss a bankruptcy petition, but rather a remedy, whatever the appropriate one would be, under state law. Now, taking a step back and looking at common wisdom, corporate control documents should not include an absolute prohibition against bankruptcy filing. I think that's what could be characterized as common wisdom. Directors or others in control must be subject to normal fiduciary duties, which would dictate that in some circumstances they would vote in favor of a bankruptcy filing if that was what was in the best interest of the constituencies that ultimately their duties ran toward. Fiduciary duties and public policy concerns also apply to situations where the blocking position is a member of an LLC. So you have the same issues connected with LLCs that you would have in the corporate context. Corporate democracy, so-called corporate democracy, involves the manner in which decisions governing the activities of a corporate entity are made. And courts have taken inconsistent views of whether shareholder participation in corporate democracy continues or is suspended following the commencement of a Chapter 11 case. In the SS Body Armor case, which is 577 BR 597, a Delaware bankruptcy decision in 2015, the court addressed the shareholder right to commence a lawsuit to compel a shareholders meeting post-petition, so post-Chapter 11. The court found that the shareholder bringing a lawsuit to compel the debtor to conduct a shareholder meeting is not required to obtain relief from the automatic stay and could bring the lawsuit. Now, the court also recognized that the bankruptcy court may enjoin the shareholders meeting, may prevent it from occurring, and also might enjoin implementation of any directives resulting from such a meeting if it was shown that the actual meeting or the implementation of what was decided at the meeting would severely undermine the debtor's reorganization. And the court viewed this, and it's sort of the standard that's been applied in this context, that when there's a, quote, clear abuse, which would involve delay or real jeopardy to the debtor's reorganization, the bankruptcy court may enjoin a shareholder meeting from taking place. On the other hand, some courts have held that disputes regarding corporate governance issues may not be within the scope of bankruptcy jurisdiction at all. In the MPX Technology case, the court found that the resolution of disputes involving corporate governance is generally not within the jurisdiction of the bankruptcy court. In the Texaco case, which dates back to 1988, the court found that the Chapter 11 reorganization process is not the place for introducing changes in Texaco's existing system of corporate governance. And at the time, it was Carl Icahn, often viewed as a corporate raider, who was seeking to have those changes made, seeking unsuccessfully at that time. In contrast, other courts have found that the bankruptcy code itself supplements or supersedes state corporate governance law when a corporation is in a Chapter 11 case. In the Shep's Food Stores case at 160 BR 79 is where some of this language appears in the decision. The court discussed that the rights and remedies of aggrieved shareholders and creditors during the post-petition and pre-plan confirmation period are regulated by the Bankruptcy Code, and said that there are numerous provisions in the code that can be viewed as supplementing corporate governance protections for shareholders during the Chapter 11 reorganization process. And further opined that Chapter 11 allows shareholders an opportunity to participate in the reorganization process and provides them with procedural and substantive safeguards. Some of the things the court was referring to include Section 363, and other related procedural protections where advance notice and court approval are required for any actions that the debtor takes during the case outside the ordinary course of business, including any kind of sale or other activities. Financing would be under Section 364, that the debtor's exclusive period, the exclusivity period for filing a plan, may be terminated under Section 1121 of the Bankruptcy Code, that in connection with the plan of reorganization, the debtor has to present a disclosure statement that contains adequate information. That's under Section 1125 of the Bankruptcy Code. Further, impaired creditors and equity holders have a right to vote on the plan, as reflected in Sections 1126 and 1129 of the Code. They may object to confirmation of the plan. There may even be a shareholders committee, an official committee of shareholders in the case, although that is pretty unusual, unlike an unsecured creditors committee, which is just routine and exists essentially in every significant Chapter 11 case. Equity holder committees are outside the norm, and I think that's generally a result of the economic realities where courts are very reluctant in a situation where they perceive equity holders likely to be out of the money to appoint a committee where the professionals would then be retained and paid out of the bankruptcy estate. So while there are equity holder committees, in some cases it's a relatively small percentage of cases. The equity holders can certainly have counsel, but they generally are not going to, unless it appears that the case is a solvent case or close to it, they're generally not going to have an official equity holders committee. And that's based on the economic realities. As the Supreme Court said back in the Weintraub case, certainly the interests of shareholders are subordinate to the interests of creditors. And if creditors are coming up short and aren't getting paid full value, and equity holders are perceived to be out of the money, the influence that they have in the case is generally going to be significantly limited, or they just simply won't have influence. And in the Sheps case, they're saying under those kinds of circumstances, it's dangerous to have state law governance provisions dictate and allow disgruntled, recalcitrant shareholders to potentially undermine the reorganization. In general, the right to compel a shareholders meeting to elect a new board continues during the Chapter 11 case. If you're to take a step back in general, that right continues. It might be argued that efforts of shareholders to call a special or annual meeting to elect a new board requires relief from the automatic stay under Section 362A3, which precludes any act to exercise control over property of the estate without advance court approval. However, courts are likely to view shareholder efforts to call a meeting as being directed towards control of corporate governance rights and not directly at property of the estate. But again, this gets into whether relief from the automatic stay will be granted, and not whether the bankruptcy court has jurisdiction to, in essence, extend the stay. It's not technically extending the stay, but to enter a special injunction to preclude certain shareholder efforts or actions. The leading case out there is the Johns Manville Corporation case at 801 F. 2nd 60. That's a Second Circuit decision back in 1986. And in that case, the Second Circuit recognized state law shareholder election rights and recognized those rights would continue and could continue post Chapter 11, but gave priority to federal interests in a successful reorganization in the event that those interests were going to conflict with state law. So if there's a conflict between the interests under state law and ordinary corporate governance and the issues and the interests under the bankruptcy code of promoting a successful reorganization, and Manville was a very complicated case driven by asbestos claimants and issues with all kinds of different parties and all types of complications. And in that particular case, the Second Circuit viewed a shareholders meeting as potentially undermining what had been a very complicated, significant and important reorganization. And the court talked about it would be appropriate to issue an injunction to prevent a shareholders meeting that was designed to replace the board of a Chapter 11 debtor if there was, again, here's the clear abuse, if there was clear abuse present in calling the meeting, and if there would be the risk of irreparable harm from such a meeting. And I think that the application of the term irreparable may stretch the meaning a bit, but that's the way the court viewed it. On remand, in that case, the bankruptcy court found that the debtor in possession was entitled to an injunction to prevent the shareholders meeting. In the Marble case, which was a Delaware District Court decision at 209 BR 832, a 1997 decision, the court followed the Manville approach, and in that case, the court was addressing a complaint for declaratory and injunctive relief to replace the debtor's board of directors. The court held that the Bankruptcy Code's automatic stay was not implicated by the exercise of the shareholder's corporate governance rights, and that the right of a shareholder to compel a shareholder's meeting for the purpose of electing a new board of directors continues during the Chapter 11 case. However, the court, again following Manville, held that the election of a new board of directors can be enjoined when circumstances demonstrating a clear abuse exist. So we get back to that standard. And in that case, the court viewed clear abuse as requiring a showing that the shareholders' actions demonstrate a willingness to risk rehabilitation altogether in order to win a larger share for equity. Now, they said, hey, the shareholders can be motivated to gain more bargaining power in the negotiation of a reorganization plan, and that alone wouldn't constitute abuse. But I think what they're looking at is if a compelling case can be made to the court that the actions of the shareholders in seeking a meeting and seeking to replace the existing board and seeking to implement certain directives that maybe come out of a new board, if a new board was appointed, if those activities or actions were likely to undermine the reorganization, evidence is presented to the court that that's the case, then there's a good chance the court would issue an injunction based on the so-called clear abuse standard. At the same time, in connection with evaluating post-petition issues relating to corporate governance and/or shareholder participation, the economic realities of the case must be considered. It doesn't make sense to kind of step out of the economic realities and just in the abstract, at least in my view, and I'm editorializing here, in my view, in the abstract, look at corporate governance separate and apart from what the realities are economically and where value exists or doesn't exist. So those considerations are important. In situations where the shareholders are clearly out of the money on a valuation basis, they should not be granted, in my view, greater rights over a debtor's reorganization than their economic interests dictate. Just as in a Chapter 11 case where it may be converted to Chapter 7 or dismissed under Section 1121, or I should say 1112 of the Code, for continuing loss or diminution of the estate and the absence of a reasonable likelihood of rehabilitation in order to prevent, and there's an absence of a reasonable likelihood of rehabilitation, in order to prevent the enterprise from gambling at the creditor's expense when there's no realistic hope of rehabilitation or reorganization, shareholders who are clearly out of the money should be precluded from diverting, diluting, or delaying estate resources by raising various arguments that really are found not to, in my view, make sense in the context of the economic realities. So to the extent that allowing state law-based corporate democracy to apply would allow shareholders to attempt to extract unjustifiable compensation, either by creating inertia or otherwise delaying the process or providing a forum for unproductive, from a reorganization perspective, litigation, the interests, in my view, of federal bankruptcy law should prevail over state law corporate governance interests. So that's something sort of at the core of a lot of this, that while state law generally is what dictates corporate governance, as it does in the authority to file a bankruptcy petition, once you get into Chapter 11, if the economic realities are such where the equity really doesn't have an honest stake in the company, then it seems that the bankruptcy code at that point needs to take precedence. Turning back for just a couple of minutes to some of the cases that address the concept of bankruptcy proofing and whether an entity can be bankruptcy proof. So before we wrap up, I want to turn back to that a little bit. In 2014, there was a decision out of the United States Bankruptcy Court for the District of Oregon. The case is called In Re Bay Club Partners. And it's a 2000 bankruptcy Lexus at 2051. 2014 bankruptcy Lexus 2051. Again, it's a 2014 decision. And that court rejected a lender's attempt to insulate its borrower from filing for bankruptcy when, at the lender's request, a bankruptcy waiver was inserted in the debtor's LLC operating agreement. So that was a case where it was clearly a lender stepping in and asserting control, in essence, over governance of the debtor. And the court declared the provision unenforceable as a matter of public policy. At the same time, courts have enforced provisions in governance documents conditioning or limiting an entity's commencement, as we discussed earlier, of a bankruptcy case through authorization requirements of majority or unanimous consent of governing boards or members. But again, those cases, members of LLCs and directors on boards need to be cognizant of their fiduciary obligations and making sure that they are acting responsibly. In contrast to Bay Club, the 10th Circuit Bankruptcy Appellate Panel found a bankruptcy waiver contained in an LLC operating agreement to be enforceable, and that was in the DB Capital Holdings case, a BAP decision in the 10th Circuit in 2010. And in that case, DB Capital was a manager operated Colorado LLC. And before its bankruptcy case, two of its members and its manager amended the operating agreement to include a provision that prohibited DB Capital from instituting a bankruptcy case. And after it defaulted on its secured loan, its mortgage lender sought a receiver, and one was appointed. In that case, the court came down with the conclusion that the provisions in the operating agreement prevented the filing. So these cases address situations where there's a strong federal policy that comes in conflict with state law. Without the federal policy against the prepetition waiver of the right to file bankruptcy, creditors could effectively remove their borrowers from the bankruptcy system, which is, of course, recognized under the Constitution. At the same time, under state law, parties forming an entity are generally able to enter into agreements governing the scope of their authority and limiting or conditioning the entity's ability to file. This continues to be an evolving kind of area of the law. There was some hope that the Fifth Circuit's decision before it was issued in franchise services would provide greater overall clarity, but because the court there didn't end up addressing all of the issues head on, as discussed earlier. This continues to be an area of a certain level of uncertainty. Now, thank you for listening to this webinar. Appreciate your attention. And for anyone who has questions, we are happy to address those, but we'll do that offline. So again, thank you very much. Appreciate your attention.